School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Presenting Block 1 Overview of Business Law, Unit 2 Concepts and Principles, Part 2.
Statutes under business law. There are various enactments brought forth by the legislature which provide guidance for carrying out business activities along with their procedure, regulation and enforcement. Some of the legislations are: Number 1. Indian Contracts Act 1872. A contract is an agreement enforceable by law. The formation of contracts plays an important role in business world, and the law of contracts in India is governed by the Indian Contract Act 1872. This law has its origins in the English common law. The drafting and formation of business contracts play an extremely important role in paving the way for business entities to establish business relationships. The Contract Act also encompasses provisions related to the laws of agency, bailment, guarantee, and indemnity. Number 2. Sales of Goods Act 1930. The Sale of Goods Act 1930 is an enactment to define and amend the law associated with the sale of goods. Earlier, falling within the purview of Chapter 7 of the Indian Contracts Act, the principles of sale of goods came to be regulated under a separate act eventually. This act performs the function of protecting the rights of buyers and sellers, laying down rules for transfer of ownership of goods, along with creation of remedies for an effective enforcement. The enactment also contains provisions for the principle of caveat emptor. Number 3. Negotiable Instruments Act 1881. Financial system encompasses credit as well as cash transactions. All transactions under the wing of finance are either dealt with cash payments or by issuance of negotiable instruments such as bills of exchange, checks or hundis, to name a few. The Negotiable Instruments Act 1881 is an act to define and modify the law relating to promissory notes, bills of exchange and checks. This enactment also ensures that obligations that are assumed by the issuance of checks as a mode of deferred payment are honored. Number 4. Indian Partnership Act 1932. The Partnership Act governs the relation between persons engaged in a business who have decided to share the profits of a business undertaken by all or any one person on behalf of all. Partnership Act is also one amongst the bundle of laws playing an important role in regulating business relations. Number 5. Limited Liability Partnership Act 2008. This act lays down provisions for the creation and regulation of limited liability partnerships or LLPs and provides a flexibility and dual benefits associated with partnerships and companies. LLP is an alternative corporate body form to conventional partnership firms where a partner's liabilities are confined to their respective investments in the business. The Limited Liability Partnerships Amendment Bill 2021 was passed by the Lok Sabha on August 9, 2021 and seeks to amend the prior act. The new act seeks to introduce certain changes providing for compounding of offences, decriminalizing certain offences, and empowering the central government to direct an LLP to change its name on certain grounds. Number 6. Companies Act 2013. Though the legal system facilitates the formation of different business organizations, a company or a corporation is the most preferred vehicle to perform industrial and commercial activities. The Companies Act 2013 was enacted to consolidate and amend the law associated with companies. The provisions of this Act shall be applicable to every company formed under the present or the previous Act, that is, Companies Act 1956. This enactment shall also apply to insurance companies, banking companies, companies engaged in the electricity generation, etc. The Act also provides for provisions in reference to corporate social responsibility. Companies Act also lays down the procedure to be followed by the companies willing to go for a restructuring in the form of mergers, amalgamation or demergers. Number 7. Employment and labor law. Employment law comprises of laws and rules that aid in the enforcement, regulation, and governing employer-employee relationships. With a view to consolidate the different legislations dealing with labor employment, industrial disputes, wages, and other employment concerned matters, this branch of law, which was traditionally governed by contract and numerous other legislations, the government in 2019 brought forth 4 bills. They are the Code of Wages 2019, the Industrial Relation Code 2020, the Occupational Safety, Health and Working Conditions Code 2020, and the Code of Social Security 2020. Employment and labor laws form an important part of the business practices being followed by the companies and enterprises and contributes in maintaining a healthy relationship between the employers and the employees. Number 8. Tax laws. The financial obligations in the form of taxes that are levied on income, capital gains, sales, property, etc. by the state government, central government, and also by local authorities such as municipality is involuntary in nature. While direct taxes are levied on taxable income earned by individuals and corporate entities, the burden to deposit taxes is on the assessees themselves. On the other hand, indirect taxes such as goods and services tax or GST are levied on the sale and provision of goods and services respectively, and the burden to collect and deposit taxes is on the sellers instead of the assessees directly. The Income Tax Act 1961 is the legislation dealing with the areas covered under direct taxes. Number 9. Antitrust laws. The Competition Act, which came into force in 2002, is an economic legislation for bringing about the economic development in our country. The primary aim of this piece of legislation is to avert practices having anti-competitive effects for the advancement of competition in the markets, to safeguard the interests of the consumers and to guarantee freedom of trade to the market participants. This legislation is the successor to Monopolies and Restrictive Trade Practices Act 1961. The Act lays down provisions relating to horizontal and vertical anti-competitive agreements having an adverse effect on competition, abuse of dominance, combinations, and their regulation. The Competition Commission of India or CCI has also embarked on investigating the conduct of any anti-competitive activities by big tech enterprises thriving on data. For instance, a recent probe conducted by the CCI has found social media giant Google guilty of stifling innovation and thwarting competition to exert its dominance in the markets related to search, app library, music, among others. The CCI probe also holds that Google has been espousing anti-competitive, unfair and restrictive trade practices by imposing one-sided contracts on devices and app makers such that its products and apps come pre-installed on the devices, garnering highest consumer preferences. The Commission will determine if this amounts to abuse of dominance under the Competition Act. Number 10. Finance laws. Finance laws are entrusted with the regulation of finance after taking into account the various risks that may be encountered amongst the financial players such as banks, NBFCs, insurance companies, etc. The main function of the finance laws is risk minimization, with the various risks being liquidity, management, credit, exchange rate, and legal, among others. This branch of law also deals with different kinds of consensual security such as mortgage, contractual lien, charge, pledge, and perfection of security interest. Law of finance also encompasses floating and fixed charges along with governing the process of consortium or syndicate finance and project finance. The Reserve Bank of India or RBI plays an extremely important role in the management and regulation of banks. For instance, last year, the central bank gave a go-ahead for the merger of debilitating Lakshmi Vilas Bank with Singapore DBS Bank's Indian subsidiary. This step was taken after many credible revival plans for the bank and safeguarding depositors failed to materialize. Number 11. Securities Law and Regulations. Securities laws and regulations, also known as capital market laws and regulations, comprise the bunch of laws and rules that oversee the issuance of securities. Securities laws and regulations advise the corporations on the steps that need to be undertaken for offering their investments to the general public. They are extremely vital to the development of the market economy. The laws associated with securities may provide regulatory or transactional assistance which assumes significant role in the conduct of business. In India, the Securities Contracts Regulation Act 1956 governs the issuance of securities. The Securities and Exchange Board of India Act or SEBI is entrusted the function of regulating the securities market and safeguarding the interest of the investors in securities. Number 12. International Business Law. International business involves the sale and purchase of goods across the border. It is the principal determinant for the aspects related to international trade and globalization. The major benefits of international business law transactions include increase in the level of profits, availability of advanced technology and raw materials to explore avenues beyond domestic markets and for facilitating growth in the market share. Number 13. Foreign exchange laws. In India, the foreign exchange regulations are governed by the Foreign Exchange Management Act 1999 or FEMA. The Reserve Bank of India is entrusted with the responsibility and management of the foreign exchange. Number 14. Consumer Protection Act 2019. The Consumer Protection Act 2019, which replaced the Act of 1986, is intended to protect the interest of the consumers and laying down rules for the settlement of consumers' disputes. This act also enlists various consumer rights such as the right to be protected against the marketing of goods, the right to be informed, the right to be heard, right to consumer awareness, and the right to seek redressal in case of exploitation, to name a few. The recent act also incorporates provisions related to product liability actions and provides procedure for mediation. Number 15. Law of arbitration. Law of arbitration plays an important role in resolution and settlement of disputes. The Arbitration and Conciliation Act of 1996 was enacted in order to define the laws in relation to conciliation and for consolidating and amending the law relating to domestic arbitration, international commercial arbitration, along with overseeing the enforcement of arbitral awards. Arbitration is being considered as an effective means for dispute resolution in addition to the usual court-conducted litigation. One of the recent instances of international arbitration has seen the case of US retail giant Amazon against the acquisition of Future Retail by Reliance Industries. The Singapore International Arbitration Center or SIAC has begun hearing the case last year and in the course of proceedings passed an emergency award supporting the claims of Amazon. The sale between Reliance and the Future Group's assets was thereby stayed. It was the contention of the Reliance Industries and Future Group that the Singapore Arbitration Centre's order was not binding in the South Asian market. However, the Indian Supreme Court upheld the verdict of Singapore's emergency arbitrator EA award and was enforceable under Section 17, Clause 2 of India's Arbitration Act. Number 16. Intellectual Property Law. Intellectual property is associated with the creations of the mind which are intangible in nature and includes literary and artistic works, inventions, and symbols. Intellectual property rights provide protection to patents, copyright, trademarks, industrial designs, geographical indications, trade secrets, and semiconductor integrated circuits layout designs. Intellectual property and technological know-how are proving immensely significant in the current industrial setup. IP law can also help provide protection to innovative products, aid in differentiating one business from its rivals, and grant protection from the mutilation or destruction of artistic works. Intellectual property has gained immense significance in the current business environment due to the value it garners for an industry. The role played by intellectual property in contributing to the research and development, that is R&D of a company, is immense, especially at the time of merger or takeover of the company. It undoubtedly holds true that intellectual property protection has been designed to promote innovation and stimulate creativity and to reward the innovators for the risk undertaken by them. Intellectual property is a must for investors and scientists to expend time and monetary resources into R&D, and in the absence of any incentives such as the expectation of financial gains in return, no one may be willing to innovate. Intellectual property in the form of patents and technological know-how have also taken up an extremely significant role in the current vaccine unavailability crisis, with big pharmaceutical companies unwilling to share the trade secrets with other countries, fearing loss of profits. There are certain legislations governing the law of intellectual property in India. They are: number 1. The Patents Act 1970. This act governs the protection of patentable inventions in India. The patent protection is offered for a period of 20 years under this act. Number 2. The Copyright Act 1957. This act provides for the consolidation of laws related to copyright protection by granting protection to literary, dramatic, musical, and artistic works, including cinematographic works and sound recordings. Under this act, copyright protection is granted for a period of 60 years plus the life of the author. Number 3. The Trademarks Act 1999. This act was enacted to consolidate the law relating to trademarks, providing for registration and protection of trademarks for goods and services, and for further preventing use of fraudulent marks. The protection for trademarks lasts for 25 years under this legislation. Number 4. The Designs Act 2000. This act was enacted to amend the law relating to protection of designs. The protection offered for the designs registered under this act is for 10 years. And number 5, the Semiconductor Integrated Circuits Layout Design Act 2000. This act was enacted to secure protection of semiconductor integrated circuits layout designs. The duration of registration under this act is for a period of 10 years. Next comes insolvency law. The Insolvency and Bankruptcy Code was enacted in the year 2016 for addressing issues related to reorganization and insolvency of individuals, partnership firms, and corporate persons in minimal time with a view to increase the value of the assets. The code further strives to promote entrepreneurship, availability of credit, and to satisfy the interest of all shareholders. Corporate insolvency resolution process under Section 14 of this Act also includes a process of declaring moratorium, which prohibits the performance of acts allowing the institution of suits, continuing the proceedings, or following up on pending suits against the corporate debtor. This provision also blocks any act that results in transfer, encumbrance, alienation, or disposal of assets by the corporate debtor, and any act seeking foreclosure, recovery, or enforcement of security interest made by the corporate debtor with regards to the property in question. And the last is Commercial Courts Act 2015. The Commercial Courts Act was brought forth in 2015 for the creation of commercial courts, commercial appellate courts, commercial division, and commercial appellate division in the high courts for resolving commercial disputes of specified value. A commercial court is empowered to handle complex commercial disputes in a time-bound manner. The Act also is embedded with specialized features such as pre-institution settlement, or offering a mode for a pre-trial conference for settlement, and case management hearing, that is, court providing a timeline before the start of the trial for the entire life cycle of the suit. Basic scheme of litigation, resolution through courts. In India, the adjudication of disputes is carried out by the judiciary. The court system follows a hierarchical structure with the Supreme Court at the apex, being the union judiciary. The Supreme Court is empowered to exercise original, appellate, and extraordinary jurisdiction. The state judiciary comprises of high courts, entrusted with the power to supervise the functioning of all other lower courts and tribunals in the country, including district courts. The adjudicatory courts are categorized into civil courts and criminal courts. India follows an adversarial form of system. A plaintiff is the party bringing a lawsuit before a court of law in pursuance of a legal remedy. A defendant is the party against whom relief is sought in a civil proceeding. The Code of Civil Procedure 1908 governs the procedure in relation to civil suits. The code lays down the substantive and procedural aspects in the form of provisions and orders drafted in the code for regulating the proceedings in courts of civil judicature. The orders provide for rules in regards to parties to the suits, framing and institution of suits, the particulars to be present in pleadings, plaints, and written statements, pronouncement of judgment or decree, among others. The code also provides rules regarding the grant of temporary and permanent injunction and summary procedure. Alternative dispute resolution. The path of litigation and use of the court system to resolve the commercial disputes usually takes years to resolve and cost a lot due to the legal fees and expenses. During the process of litigation, the normal business operations are hampered and disrupted. In order to avoid these issues, the businesses usually prefer the mode of settlement without involving the courts. Here, the disputes are resolved outside the court judicial system, and this is often referred to as the Alternative Dispute Resolution, or ADR. ADR is being increasingly used to resolve legal problems as it provides many benefits in terms of quick redressal and resolution and are much cheaper than litigation. ADR includes within its scope arbitration, negotiation, and mediation. The active participation by the parties in the negotiations produce satisfying results for both the parties. The flexibility offered by the ADR methods can prove useful in combating the ever-increasing backlog of cases. These also address the delays associated with the onerous procedure of litigation. The sheer volume of cases, lengthy and time-consuming procedures for appeals and review further aggravate the delays in the finality of proceedings in an adversarial setup, overwhelming the system. This may also thwart investments as firms looking to invest in the country may become cautious on evaluation of legal and financial risk that the exit mechanism may be drawn out pending the resolution of laborious litigation. ADR techniques are gaining popularity due to the flexibility in procedures and the wide range of innovative solutions available at disposal based on the problem at hand, sidestepping the rigidity associated with precedents, giving rise to creative ideas. The technique of ADR is an effort to design a workable and fair alternative to a traditional judicial system. It is a fast-track system of dispensing justice. These techniques have been developed on scientific lines in USA, UK, France, Canada, China, Japan, South Africa, Australia, and Singapore. ADR has emerged as a significant movement in these countries and has not only helped reduce cost and time taken for resolution of disputes, but also in providing a congenial atmosphere and a less formal and less complicated forum for various types of disputes. The advantage of ADR is that it is more flexible and avoids seeking recourse to the courts. In conciliation or mediation, parties are free to withdraw at any stage of time. It has been seen that resolution of disputes is quicker and cheaper through ADR. The parties involved in ADR do not develop strained relations, rather they maintain the continued relationship between themselves. Section 89 of the Civil Procedure Code or CPC 1908 enlists the different ADR techniques that the court may refer to after reformulating the terms of possible settlement between the parties if it appears to the court that the parties to the dispute may be willing to settle. The court may formulate the terms of settlement of a dispute and after receiving observations of parties, refer the terms to arbitration, conciliation, judicial settlement through Lok Adalat or mediation. Now let's summarize the unit. The diverse set of legislations enacted by the law-making bodies promote effective regulation and promotion of business activities and aid in designing a framework which encourages smaller enterprises to expand their business offering a level playing field. Thus, business laws play a significant role in shaping the economy of the country.
We were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC-013 Business Law. Course coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.